based on all his past experience, he had no reason to believe were wrong, were lying, or were misleading him. When General Markač ordered the Luchko commander, Mr. Turkal, to get written reports from the group leaders related to Gruberi on September 1st, 1995, a reasonable measure, those reports all stated that armed conflict occurred in Gruberi on the 25th. What was the use for him to conduct any further administrative questioning? There is no evidence that any single person told or reported to General Markač that what happened in Gruberi was in fact a crime. Paragraph 389. Here we find highly suggestive but characteristically unspecific references to criminal conduct. The most troubling is the truly silly allegation of mens rea, grounded on knowledge that elderly persons were present in an area of operations. Exactly what additional duty did the presence of elderly persons impose on Markač under the OTP's theory? If we look at paragraph 391, Markač was aware of the substantial likelihood that murder would be committed in the execution of his plans for the Gruberi operation. We scroll down to the footnote, please. 2 cases are cited for this. How is that evidence? Paragraph 391. Here the prosecution alleges Markač prompted the special police, quote, to commit crimes in relation to Gruberi, end quote. Further, the OTP alleges failure to take reasonable and necessary measures to prevent punished crimes by his forces, quote, thereby creating a climate of impunity, end quote. This passage is truly representative of the modus operandi of the brief that I mentioned above. This paragraph conflates issuing orders for lawful military operations with specifically intending unlawful acts. It's missing precisely what the law requires, a connection between crimes and a specific failure on the part of the commander. The conclusions the OTP is asked the court to draw from these generalized facts are entirely unsupported. The OTP never tells us what necessary or reasonable measures General Markač was supposed to take, just that he didn't take them. Why? Because they know from their own witness, State Prosecutor Željko Žganjer, that the only entity that could deal with murder and other serious crimes was the crime police, not the special police. And this is transcript reference 11609 to 10. Paragraph 395. Prosecution says Markač was physically present on the scene of crimes committed by his subordinates. This is another misleading suggestion, attempting a connection between a very general statement and criminal responsibility. This passage suggests Markač's presence at the scene of crimes, and because of that he's therefore criminally liable. The invitation to error is to conclude that Markač is physically present at crimes and actually declined opportunities to personally interrupt acts of criminal violence. It is no wonder that this paragraph includes no citation to 2.5 years of evidence, and also no wonder the allegation isn't elaborated in later sections of the brief. The OTP spends a scant 3 paragraphs on superior responsibility with not one citation to the appropriate case law. Regarding this discussion of superior liability, the OTP's neglect of the evidence before the court is striking. Despite detailed evidence presented to this court concerning the actual extent of General Markač's authority within the MUP, Here the OTP relates his authority in the most general terms. This characterization, of course, better suits their urging of his culpability based on his position rather than his conduct. This is a gross departure from the legal standard of superior responsibility. Paragraph 398 is an allegation of actual notice of crimes without citation to authority. Even so, it recites a simplified account of a superior's duties with respect to knowledge of crimes. Here they would have this court understand that leaders have no option other than to punish. This passage conveniently neglects widely recognized legal effect of reporting of offenses to responsible authorities. Moreover, not one single mention is made of the general media and NGO awareness of the events in question. Everyone from Minister of the Interior Jarnjak to Joško Modić to Stjepan Buhin to Ivan Čermaka to Željko Sačić to Witness 86 and Witness 84 are alleged to have been advised about bribery. Yet Markač is the one who is alleged to be criminally responsible for it, despite the fact that it is the crime police that is responsible to conduct these criminal investigations. Another crucially misleading characterization of Markač's authority is brought forth in paragraph 403 relating to, quote, assisting criminal police in investigation when necessary, end quote. This argument is dealt with in Markač defense brief paragraphs 133 to 93, so I won't go into it in detail. But, as I've stated earlier, criminal offenses, their investigation, the power is vested in the criminal police sector of MUP, D 527, Article 17. The prosecutor knows all too well the significance of this suggestion, especially in light of the Bashkovsky decision, where the conduct alleged there, including murder, grave violence, and destruction of homes and property, were criminal offenses which the trial chamber there found could not be adequately handled internally by the Ministry of Interior as an internal disciplinary breach. And I cite that trial chamber decision at 521. I think it's important for the chamber to hear specifics about the Bashkovsky trial judgment and appeals judgment because it's so similar to the case that we are dealing with respect to General Markač. And I'm talking about specifically paragraph 523 to 526 of the trial judgment. The evidence presented indicate in the Bashkovsky case that he was present as Minister of Interior for over an hour at a house while 10 ethnic Albanians were being held there, guarded by police. Prisoners were lying face down with their heads covered. Bashkovsky was told they were terrorists who had been captured. While he was in the village, he heard firing and could see houses burning. Even though the chamber, in that case, established from the evidence presented, the men being held had been severely beaten prior to the time Bashkovsky had seen them, they could not conclude from the evidence that Bashkovsky witnessed any mistreatment or, quote, should have deduced from the appearance of the 10 that there had been criminal mistreatment, end quote. Similarly, even though homes were burning, the chamber concluded that no evidence presented proved that Bashkovsky should have known that there was arson or wanton destruction of property. The chamber found that he had been supplied an explanation by the police that there had been an armed conflict between the security forces and terrorists, coupled with the testimony that he had been shown 3 firearms and ammunition that he was told were seized from the terrorists, and that's sufficient to support Bashkovsky's understanding of the event. The trial chamber found no evidence that Bashkovsky saw or was told of any person being shot or killed while visiting the village. In affirming the acquittal, the appeals chamber stated that the information in possession of the civilian police determined in the ordinary course to have led an investigative judge and the public prosecutor to conduct a proper investigation as anticipated by the law in such circumstances. Though evidence presented did not confirm that Bashkovsky had ordered the notification to the criminal police, the record indicated that members of police officers in his ministry passed the relevant information on to competent authorities. That's at paragraph 267. The similarity between the Bashkovsky case and the case facing General Markač is striking. One important difference: General Markač was never in Grubery. General Markač never saw with his own eyes what happened there. General Markač learned everything about Grubery from written reports from subordinates who were on the scene or who participated in the action. Those written reports talked about armed conflict. Let's look at reasonableness from General Markač's standpoint with respect to Grubery. He gets notice the evening of August 25th that something happened in an area where his forces were operating. He sends his chief of staff, Željko Sačić, to find out more information. The same day he gets this information. The next day his chief of staff sets out for Knin, and he finds out from his chief of staff that there are dead bodies and that there are police on the scene. Now, if a crime occurred, it is the competence of the MUP criminal police to investigate it. If the deaths were not in fact the result of lawful armed conflict, they had a legal obligation to investigate. All the information in General Markač's possession is relayed to him by others. Even Bashkovsky, who is on the scene seeing the burning, is not held criminally responsible for failing to act. Unless General Markač has information which has been provided to him which is to the contrary, there is no reason for him not to believe what he's learned from his subordinates. In addition, Witness 86 and Witness Buhin were waiting for instructions from Ivica Cetina, the head of the Zadar crime police, under whose jurisdiction any criminal investigation fell. This is Witness 86's testimony at transcript 5292. Paragraph 433 of the prosecution's brief. Even where the prosecutor admits that Markač initiated investigative efforts commensurate with his resources and authority, the prosecutor attributes ungrounded nefarious motives to these efforts. Paragraph 434 alleges that Markač had a discussion with Čermak about what Čermak would say to UN TV. This is undocumented, unsubstantiated, and non-existent. There is no factual reference that General Markač talked to General Čermak about anything related to Grubery other than the initial notice that something happened on August 25th. This is an effort to construct an agreement between Čermak and Markač to mislead regarding the events of the day. Paragraph 439. Almost every act in this paragraph is alleged to be independent of anything Markač did. This and subsequent paragraphs paint the picture that Željko Sačić could sphere and independently wield enough influence to cow witnesses 84, 86, an entire office of police authorities, as well as Čermak, Morić, Jarnjak, Cetina, and Buhin. Paragraphs 442 and 443. At this point in the brief, as to Markač's own actions, it appears the prosecutor would have both ways. In this unbelievable